Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
That's correct.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
From C. Dahil mihi Anglican police, verbal club.
That's literally not true.
I didn't ask you to interrupt me.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. And now I can see you. No, I could see you before. Blue blockers only. Let's see. I'm trying to see what's going on in chat here. Not allowed to sit down yet. Okay. Let me figure it out. We've had some issues on YouTube recently, and before I turn the chat on, let me see if I can fix that. Is it still not working? I'm just going to restart it. All the way shut down, restart it. Coming back up. Looking good. I've got all green checks. Hopefully the next person to chat is the winner. There it is. Boom. It worked. And for some reason, once again, I win. I don't know why. I'm just getting all the points. Greeners, welcome. You were actually first in chat today. Let's see. Greeners, congratulations. You're first. In the real chat, I was first in the Lumia stream version of the chat, which is a little bit different. So we're going to punish you, Greeners, with internet ownership. Everything IP-related worldwide. If it breaks, is your fault. Going here forward. Red Pen, yes, you are here. Welcome. I'm curious what my points are, having won 6 times. Let me do a little check here. Do I have points? I'm ranked 202. What? 202. Oh, no, points balance is 202. That's like the last place is where I am. Never mind. All right, I'm in last place. I'm losing. All right, let's see. We have court to go back to in just a moment, which is great. There's been some talk of possibly a question. I haven't heard anything beyond that, but we'll see if something comes back. See if it works or not. All right. Anything else? Did I miss the verdict on Thornton Thomas? You did. You did. Sorry. It was an interesting one. I'll tell you that. It was a mixed verdict. It was 2 hung jury questions. The two assault charges the jury was hung on, and by different counts. One was like 11-1, and one was like a 8-5 or something. I forget whatever the math was. And then he was not guilty on 2 other charges. So favored guilty of the assault and not guilty of the others, but pretty cool outcome there for him. And thank you, Legally Blonde, for being our court watcher for that. Are we going to do some court hopping so we're not stuck staring at the sentence for the next few hours? What's wrong with this sentence? Just kidding. Yes, we will. Legally Blonde, here's the hung on 2 and 3, 5-7 guilty on there. See, the math was wrong. 5-7 guilty on 2, 11-1 guilty on 3. That's the true count. How do you get points? Just being here is one way. Being first in chat is another. Obviously, I think super chats and super stickers and all that is another way. But just being here and interacting in chat respectfully, liking the stream, it all helps. Gets you points. Remember when we stared at the button on the wall for so many hours? Oh, please give me the button back. I love the button. I can stare at the jury notification button all day long. All day long. I can do that. All right. Welcome. Hope your lunch was great. I didn't have much. I was busy. I was trying to do stuff. And Francis Fitzgerald, thank you. I've actually been on with Peter Tragos once before and loved it. Tons of respect for him. He's amazing guy, amazing lawyer, great legal mind, a lot of fun to interact with, and just genuine off stream and on. I mean, what more could you want? Yeah, it's really good. Let's see, Selena, I had to clear that off to make room for this one, and it wasn't a terribly good trial. Let's see. It is his birthday. That is great. We sang to him this morning. Happy birthday, Peter. Hope you have a great birthday. You get some golf in. Maybe, I don't know. I'm not sure if he's going to be in Florida or North Carolina. It's a nice time. It's a nice crisp time to get some golf in North Carolina right now. Jake Harrell, father of missing baby Emmanuel in California, has pleaded guilty to second-degree murder per Brian Enton. Thank you, Amber, for that update. I saw that come across on X a little bit ago. And they're still looking for his body, right? They still haven't found Emmanuel's body. That was my understanding. What did Teespring say out of curiosity? Nothing yet. I'm waiting for a response. It's we'll call you back. You forgot to tell me about Thornton's pillows? Legally Blonde, you know the number. You can remedy this right now. Let's see. Or not. It's fine. See where I rank. Oh, here she is.
Call from
Legally Blonde.
Legally Blonde. I want to hear about the pillows. How are you doing?
Okay, so, just living that dream.
Mm-hmm.
That's what they say, right?
Yes.
So his mom, I was sat out in the hallway with his mom all morning because the stream wasn't up. So she was telling me those pillows, his daughter's mother bought them in the fundraiser or whatever. But why they were so important was she died 3 years ago.
Yeah.
So those pillows
they're sentimental.
Are yes, they're the last gifts that she gave him. So they remind him of his, the mother of his child. Yeah. And it was the woman he was with when he originally went away, and of his daughter. So, and that's why he had so many of them. It was and I think his mom kind of alluded to he's like a is it creature, comfort creature, whatever they say. Yeah. He's someone that he likes those comfort items. And so and here's the other thing. So the reason why he has PTSD, he talked about it, but they wouldn't let him get into why he has it. Mm-hmm. He was robbed at gunpoint and shot. Ooh. A year before he was arrested. And he has a PTSD diagnosis from being shot. And she did tell me a little bit about his conviction. It was not in Warren County. It was in Summit County. And I didn't know this. Did you know that they could just transfer prisoners anywhere in the state, no matter where they're convicted?
Yeah, they can do that. They move them around entirely up to the Department of Corrections.
Yeah, I had no idea. So he was convicted in Summit County and while it was a home invasion, it was with his 20-year-old stepson. Now, listen, we do have to take this for what it is. She's his mom.
Right. So we're getting the story from a certain angle.
Right. There is going to be a bias thing there. But he has always everyone's innocent in prison,
right?
That's what they say. But he has always stood by the fact that he did not do this burglary, that whatever happened, he wasn't even there. It was his stepson. His stepson kind of built like him and had on his face mask. And how they got him was his DNA was in the face mask.
Whoa.
And that's how they connected him to the crime. And he was no one died in that. I'm not saying that makes it okay.
Probably a photograph.
Judge is back.
Go ahead.
Referenced in your
okay, that's fine. To be continued.
Okay, thank you, Legally Blonde.
Bye.
Appreciate it.
Bye.
And Judge.
Hold on. And then Mary-Lise, I'm going to have those 5 as a
Teresa, welcome to the gallery. Oh, gee.
Mr. Damas, I'm going to give them back to you. Let the clerk mark them as a composite.
Before we do that, I need to swap out a photograph.
So there's 5 right now, but one of them is a duplicate?
Correct.
You only want me to mark it, right?
Just mark it for now.
2G.
So the substance of the photographs that the state referenced in their closing are the outside of Miss Daisy's home, which encompasses a duplex. There is a 5th one that, Mr. Tomas, you found in your discovery.
Yes, ma'am.
And what does that one show?
So that one shows inside, shows the home, shows the door, I believe it's the back door, and very close to the back door there's a window that you can tell it's in place of glass, there are other things there.
Cardboard.
And I think this would go towards the specific question that the jury asked about, I think they were alluding to the testimony that Pedro stuck his hand through the window to unlock the door.
Because at one point during the state's closing, some reference was made about how tall he was, and Mr. Brigida is not as tall as him. Something along those lines. If you remember it better than me, let me know. But something along the lines of reaching in and how nothing of the outside. The inference was nothing on the outside was damaged. From where I was sitting, that was the gist of the state's closing argument on that point.
Yeah, I recall, I guess the impression that I got was that this that I'm showing you shows that he couldn't have reached in and opened the door.
I got the same impression. Yeah. But those photographs that were used as a demonstrative aid are not in evidence?
Well, so yes and no. When I was creating this presentation yesterday, I had a good faith basis to believe that at least some, if not all, of these photos are in evidence. I obviously do not have access to evidence once we are done for the day. I have reason to believe, based off of the testimony, as well as the introduction, as well as the conversations I've had with co-counsels, that those photographs were introduced. The other photograph, and it's 100% my fault. I missed it. Mr. Jamal brought it to my attention when we were outside of the hall, I believe. I would not have made the argument that I had made. I would have changed it a little bit. It would have been something similar, but I still would have made the same argument. But I still have reason to believe those 4 should be.
So just print out the duplicate one. Are you going to go get it for us, Mr. Aftala?
Yes, Your Honor. I'll go to the back. Or no, actually I have to go to across the street and go and grab it.
Can you make your way over there now?
Run.
Thank you.
Run your little legs.
So how else do I fix this?
I don't believe it's fundamental error, Your Honor. I understand your concern. I genuinely do. And
fundamental error.
I lean conservative when it comes to. No, I'm sorry. I lean very conservative when it comes to those kinds of things. It wasn't a predominant feature of my closing.
It was the first question that the jury. They're in there for maybe 10 or 15 minutes, and that was the first question that they had for us.
I understand. If the court wants to send an instruction back.
Do you have any other suggestions?
I think by agreement we can send in those photos. I don't know what else the court had in mind.
By agreement, you referenced the tattoo of Daisy on his arm. That was part of the autopsy. That photo may not have been part of the evidence. By agreement of the parties, we agreed because it was referenced in the autopsy. It went back as stipulation. That was number 30 what? 31. This is a little different. It's one thing for them to be in a 9-year relationship. They've got 2 kids. They love each other. There's ups and downs. Him having Daisy on his arm, that corroborates parts of the state's case, doesn't go to the core of either the elements of the crime or the defense to the crime. This does, because it goes to credibility of witnesses. Why shouldn't I bring this jury out and allow Mr. Tomas a minute to explain to them his version of that photograph?
That's fine.
So the only issue is with that, and genuinely, like, I understand, of course, concerns. I have the same concerns. Had I known that this photograph with the back door existed, and it's 100% my screw up, I am completely at fault.
Listen, I take you at your word.
I missed this. I would have still used this photograph, and I would have explained the same exact thing. I don't have an issue with Mr. Tomas being able to explain his version of events.
What would you have explained?
I would have said the window is still far from the door, and that this window appears like it was fixed, and if all of this was going on in the middle of the night, do we really think that this got fixed between the time and the shooting? That's what the argument I would have made.
But your argument is premised upon what you remember of these witnesses saying he stuck his hand through the door that day. I don't remember that specifically.
No, I believe the defendant's mother said that happened that night in between her being choked, or not the defendant's mother being choked, but the defendant being choked.
I don't remember. What do you remember? Why don't you confer with your client also?
A fundamental error is an exceptionally serious and prejudicial mistake that goes to the core of the case or violates a party's due process rights, even if not objected to at the time. It is an error so severe that it compromises the fairness and integrity of the trial, making it potentially a ground for an appeal even without a timely objection. Examples include a prosecutor misrepresenting evidence to the jury or making arguments that unfairly attack the opposing counsel's integrity. I think what we have here...
The other exhibit was also by agreement of the parties, 31, and this one would be 32, right? Okay.
We have pictures going back to the jury in response to a question.
Photo is 31, that was by agreement of the parties, and this would be 32. All right, yes, Mr.
So,
Tomas.
Judge, two things. It's hard for me to remember exactly when, but I believe that at some point, Ms. Link, during her testimony, she referenced that she noticed things were missing, and that she had reason to believe that Mr. Jimenez somehow got in through an opening of the window. But her mother did testify that she saw him reaching in through the window, and that would have been the
day of.
The day afternoon, evening, prior to the early morning shooting. So that was my recollection of the testimony.
You know what? I screwed up. I would take the fault of it. I will let the court make the decision and just take it on the chin.
Okay. So if I'm gonna let you talk to the jury for about a minute, what would you say? And I will instruct them that these are the photographs that the court believes they're referencing in their question. They were used as demonstratives, but they are now being admitted by agreement of the parties.
They weren't evidence and they went back?
Actually, Marilise, yours will be separate.
Okay.
So the 4 for the state will be 32. Yours will be, can it be 33? State's 33? It'll be state's 33.
Mr. Artall is bringing the last photograph.
Somebody has a state as well?
I'm sorry, yeah. The one of the inside is going to be 33. Can you separate it? Yeah, that one's going to be 33.
Are we surprised at all that this is resulting in the
I'm
cluster?
sorry, what would you argue?
I would just say so, ladies and gentlemen, this is a photo from the inside of the home, and as you can see, the door, the window next to the door, it's visibly within arm's reach, and as you can see, the glass is kind of replaced with other items kind of in place of the glass, and this is where Mr. Jimenez would have been able to reach through to unlock the door from the inside from the outside.
Okay.
And that's it.
Are you in agreement with that? Okay, because it wasn't, I think you can appreciate, Ms. Link, these photos that the state referenced in closing weren't introduced into evidence, but they were on the television. And I think that's what the jury is asking about. That was their first question.
He had them in his closing.
In order to remedy this, which is error.
Oh my goodness.
I don't know if it's fundamental error, but it's error. I think it's fair for me to allow your lawyer to introduce the one of the inside of the house that has cardboard with Modelo taped or appears to be taped on the window, and for him to at least address the jury about a minute to make his argument to rebut the photographs of the outside that the state argued showed no damage. Does that make sense?
Yes, ma'am.
Okay. So,
I'm just waiting to start.
yeah, it's fine.
Prosecutor
so we can go off
used-
record while we wait. So the
it's
four
closing.
photographs of the outside of the home that were referenced as a demonstrative or composite 32, and the one of the inside with the cardboard that shows potential damage is 33. So we can go off record while we wait for Mr. Aktala to come back so we could staple it to the to 32. Thanks,
So
Stephanie.
either in the state's case or in the closing, the state used photos and showed the jury photos that were not admitted as evidence. I think this is closing because he should only be referencing the evidence in the closing, not more material. So I'm leaning towards closing is when it was used, because there can be exhibits that are not admitted as evidence, to show that there was no break-in, and now there's a picture that exists that could show that there was damaged windows. This is wild. I wish I knew the wording of the juror's question. If you guys can see, if anyone's posted it on the Twitter sphere, let me know what that question is. Prosecution screwed up. He said, I'm going to take it on the chin. Oh, look, it's a different font. Greeners, it's a different font. It's not quite Comic Sans Serif, but it's sans serif at least. Okay, hang on. I'm looking for the Daisy link. See if they can tell us what the question was. I'm not seeing it. Has anyone seen it? Is this grounds for a mistrial? Possibly. We're filming the jury room. Nice.
Okay. Mr. Tomas, you can go ahead and hold on to them.
Yes, ma'am.
Meredith,
Take the
you can give
paper.
that to Mr. Tomas. All right, folks, we're back. Thank you. So 1, 2, 3, 4, 5, 6. All jurors are present, lawyers as well as Ms. Link. Okay. In order to best answer what I think you were asking, the lawyers also think the same regarding your first question. There are 4 photographs that the state referenced in their closing. Those were demonstratives, so they were not in evidence. By agreement of the parties, they are now introduced into evidence. 4 photographs, 1 composite, number 32. It'll be a state exhibit. In fairness to the defense, because those items were not introduced into evidence, I'm allowing states 33 in Mr. Tomas's hand, and he'll be able to address you for about a minute as a rebuttal to what was not introduced into evidence, okay? Go ahead, Mr. Tomas.
Wow.
So, ladies and gentlemen, this is a photo for your consideration. This is Exhibit 33. As you can see in this photo, here is the door, photo from the inside of the house. This door is in close proximity to this window. And as you can see, this window has items taped which are taking the place of the glass. So instead of having glass, this window is really covered up by these, I guess, cardboard items, and you can see that they're taped together. So this is being submitted to you because, as you can see, Mr. Jimenez could have feasibly, from the outside of the house, stuck his hand in through this open window, reached the door, and unlocked it and opened it from the outside. So I believe this was relevant for your consideration. It's Exhibit 33. It's going to go back with you, and you can look at it as much
We'll
as
hand
you
it. We'll hand it to you now. 32 and 33. We'll hand them to you now, and you can continue your deliberations. Thank you.
Wow. To new court? Yes. This is a mess. was that by agreement?
Alrighty, they've now gone back in. I'll be upstairs. We can go off record if anybody.
Before we do that, I just want to apologize again. It's entirely my fault. I did not. I missed it. I just want to put it on the record. It's entirely on me. And I
Understood.
It's an honest mistake. We all make mistakes.
And I think we remedied it, and by allowing you, Mr. Tomas, to directly address the jury and point out what you wanted to point out, I think it took care of it.
I
So
appreciate it.
we'll see where it goes. Thank you.
What's with the music? All right, Timu Court it is. All right, here we go. Ballroom music, it's dancing time. I kept the timer going because really, stopping it for 2 minutes of a little instruction. This is sort of, they're still deliberating in their heads as we speak. As a jury member, how would it feel for be currently deliberating and be pulled out and like, hey, send him back more evidence, got some more stuff. And we're going to have just one, we're going to have one more rebuttal closing, a rebuttal or a recross. What do you call that when the defense gets to go last? Not having the burden of proof. This is just so messed up. We fixed it. The prosecutor almost had this not been able to be remedied. Could have been this fundamental error that occurred. It's called revenge. Is it called putting your hand on the scale of justice? A Band-Aid? Oh my goodness. We did birthdays this morning. We did. Peter Chagos is having a birthday today. A little goat scream, maybe. More like a piece of gauze. How not to do trial 101. Defense has been a great advocate. In my opinion, the pros not so great, but I loathe this defendant for reasons that aren't directly connected to her accusation, except she wouldn't have inseminated. Yeah. Okay. Yeah, that's the after arrest actions are pretty crazy. Can they legally admit evidence after arresting? I've seen it done like in the immediate after they go back. It's like, oops, we made a mistake. This is supposed to be included, but it's in the process of them gathering everything up. I think we've seen that before. But after they've started deliberating, they've asked a question, and then you're like, oh, got a question about that? Have I got something to show you? That's a weird time to bring something in. 4 or 5 new pictures. And then have another closing. And it's only one-sided. The state doesn't get to say, there's no way he could have reached his arm from that window all the way over to here. There's no way. Rules don't exist in this courtroom. State can never be trusted. Look at Alec Baldwin. Alec was in, are you saying the state in general? Every state cannot be trusted. Are you talking about Florida or Arizona or New Mexico or what? Surrebuttal is the response. So we got a surrebuttal ending. The jury doesn't even know about the vent baby. Wow. They probably know about it, but don't know this is the case. Don't see the big deal. I think that once the jury starts deliberating, they're hands off. And any additional interaction to influence the outcome would be highly suspect, in my opinion, especially if it only comes from one side. It's payback for not letting them use the jail calls. No, this is punishing the same side. The prosecution wanted the jail calls, and the prosecution is getting whooped by only getting one side tell what the picture means. I guess he sort of used it in his closing, so it's all fair. Haven't found the question yet. No. If anyone finds it, please let me know. Yeah, this attorney's not going to ask for a mistrial because he's confident in the not guilty verdict. Also, that this lawyer is also an appeals attorney, so he knows what he's doing and the steps. No, on the mistrial, it hasn't been asked for. Stop saying vent, baby. What's the alternative? I mean, baby is the term. The child's a child, but making reference to this particular one does have some unique conception facts. It's because he lied during his closing, saying the picture didn't exist. Salty Spoon, I didn't see that. He said he used it in his closing. Oh, wait. I hear what you're saying. He showed a picture from the outside and saying there's no proof. I hear you. So you're right. Salty Spoon, you're absolutely right. He said there was no evidence to show that happened. And he showed the picture from outside that looked like there was no damage or something. Just one more lie. Why would we need a mistrial? I missed it. I don't think we would. I think the defense is in great shape as far as, other than having your client on trial for murder, they're in really good shape. There's a good chance they're going to get a not guilty verdict here. Will there be a new judge if a mistrial or a not guilty verdict? Not guilty verdict, there will not be a new judge. That will be, because that would be double jeopardy. Should be tried again for the same thing. If a mistrial, I hope there's a new judge. Passing anything through the vents is illegal while you're incarcerated. You're not allowed to do any of that. In vitro fertilization. That's it. All right. Let's get set to take a peek around the world of true crime and see what else is happening as we're let's see. I'm gonna have to shuffle everything around. Put this one here. Super source, box source 3 is going to be 7. That didn't work. Hold, please. Oh, box 2 is going to be 7, sorry. There we go. Now let's see what we have in the world of true crime. All right, Judge Stephanie Boyd is up. We have Judge Simpson. He's got a PCC docket. That might be exciting. Let's jump in there. I think we're waiting for the judge to come in. Laura there in the top corner has a tricycle on top of her bookshelf. It's pretty cool. Who am I hiding? Attorney Paul Taylor. Wearing a Britney Spears headset. Looks good. Nate Bryce. Clearly a defendant. I'm calling that one. Cameron Baker. Turn that on. I still can't find the actual question, the words of the question. You're late, Cass. Punishment for being late is you have to rewind. You have to rewind and then play catch up. I'm sorry. We have rules. We have rules. Red Pen says buffer. Josh, buffer him for what? Mod chat. Okay. Judge Corey Wiggins, personal meeting room. Let's try that one. You guys ready? Ready to jump with me? Josh has a suggestion that we can watch during this. Judge Corey J. Wiggins. It's 84th District Court, right? Give me a second. It shows stuff from a month ago, Josh. And that's it. It's not there. Maybe this is the wrong one. '84th District. No. Have to get to it on Apple TV, Josh. It's a little difficult. So. There we go. Got one day ago. Finally got it. There's like just too many accounts that are all using the same name. And we're looking for one day ago. It's 52 minutes long, and to watch the whole thing, Josh says. Get a whole hour of good fun. Okay, here we go. All right. We're there. We're there. Can you guys see it?
Mr. Niegos, we are just waiting for the jail to join us.
Yes, sir.
Let's skip ahead a couple seconds, shall we? Still not there. There we go.
All right, court calls the people of the state of Michigan versus Bobby Lee Du Bois, case number 253691 FY. Appearances counsel, starting with the prosecutor.
Joanna Curie for the people.
Good afternoon, Your Honor. Ryan Niegos appearing on behalf of Brandon Du Bois.
And we are here for a preliminary examination on a possession of methamphetamine case and a resist and obstruct case. Mr. Gallegos, I know you had mentioned some issues before we actually got the case called. Is there anything you'd like to address on the record?
Yes, Your Honor. I would just ask my client to confirm. We had a discussion yesterday. He indicated some concerns about a potential change or a request that the court recuse itself such that a different district court judge would hear this matter given the court's prior employment status. In my discussion with Mr. Du Bois yesterday, my conclusion was that it was insufficient to even make the request, but I would just ask for the court to ask of my client at this point in time, or allow me to ask him, basically, Bobby, do you want me to ask the court to recuse itself at this point in time based on what you and I spoke about last night?
I do, and there's a couple other things that I would ask the court to hear me on before that as well. I'm not sure if the court is aware that there is an open investigation on the said officers that
Okay.
were
No.
involved
No. We're not gonna do that. I'm on Zoom. We're not doing this. So if you believe that because Judge Wiggins was the prior Wexford County prosecutor and had worked in the prosecutor's office, are you asking me that I ask that he recuse himself, knowing that there's going to be a new judge that's going to be presiding, likely Judge Ransom, which is going to mean additional delays just to have this hearing done? You understand that?
I do.
Judge, based on my client's discussion yesterday, based on his representations today, understanding how clairvoyant and I guess that's not the right word, just how candid and transparent this court is in terms of its beliefs. I'm not sure ultimately, Mr. Du Bois is of the opinion that, he was previously prosecutor or attempts at prosecution were such when you were either the elected prosecutor or you were an assistant prosecutor. Based on his representations and his concerns on record today, and the fact that he's telling the court he understands this is going to be additional delay in proceeding to a preliminary exam, I would ask that the court graciously recuse itself, and I assume Judge Ransom would be the step-in judge.
Ms. Carey?
That's bold. Sharon Ken Sharp, member of the jury, 30 months, OG.
You were the prior prosecutor, and I don't think that alone is enough for you to recuse yourself, and it sounds a little bit like judge shopping on the defendant's part, frankly. So I would ask the court to deny the motion.
Thank you.
All right, we're going to jump back to this in just a little bit, but right now we're going to go down here. Right here. Because... You wouldn't believe it if you didn't see it for yourself, but this trial has managed to make it all the way to a verdict. The jury has indicated they have reached a verdict in the trial of Daisy Vance. She is charged with shooting her husband, or husband as the case may be, in the back. Well, not in the back, but in the back of the foot and in the other leg. He died from blood loss after that shot. She says it was sort of in self-defense. The court shot that down. And then she stood trial and argued that, in fact, she was in fear of her life as he had been abusive to her, and that there was only, her defense said there was only one solution you could do here, that the Florida law allows her to shoot someone because he was about to commit the felony of burglary or imprisoning her children away from her because she said he was running into her house to lock her out. In Florida law, that is a crime guilty of death if caught in the act by somebody who, has the means to fix it. And an hour and 42 minutes of deliberation. This is a very, very quick verdict. We have 6 deliberating jurors. 6 people have been obviously unanimous on this. one way or the other. And the craziest thing is that the jury probably already had the verdict. It was just filling out the form when they got additional information from the judge, additional photographs admitted to them after they had been deliberating, and additional testimony or explanation from the defense during deliberation. This is wild. We have a verdict. The verdict is in. We're just waiting for everybody to gather in the courtroom, the jury to be brought in. We'll hear from them themselves. And all we can ask is that we accept justice in whatever form it's delivered. We who labor here seek only the truth. Some of us seek a change in what we've seen in this courtroom. Not happy with the judge, not happy with the prosecution. Defense has done a respectable job. But this has been a circus that only Miami-Dade could deliver. Speaking deliver, the defendant in this case is most notably well known for something she did after she was incarcerated, becoming pregnant through the vent, through a package to her, and she gave birth to that child. That child's now, I believe, in the custody of the father's grandparents or something like that. It's a family member that has that child. And she's mad at the state for not keeping her from getting pregnant, and possibly might sue them, because it was their fault apparently. And she says, they never once have they thanked me for showing them how they had lapses in their security system. Please never do a trial with this judge again. I hope she never does another trial. I have to say that. I'm not happy with this. No matter what the verdict is, it's not going to feel right. It looks like we had hands on the scales of justice. It looks like we had a personal measuring match going on between different sides at different times. I mean, it's been bad. It's been bad. The audacity. Please be respectful regardless of the verdict. Thank you very much for that. Let's see. This one feels icky. It's a mess. What was the poll result? We were about 52% not guilty. Fast verdict is usually the most obvious, which is usually guilty, to be honest. But for this one, not guilty in my opinion, says Allie. Our poll results were 52% not guilty. Didn't see enough, so I can't vote. Have no idea on guilty or not guilty. I've told you my thoughts on this one. I think what we have here is somebody who tried to commit murder and found out in court while being prosecuted that, in fact, what they did might have been legal. That is how I feel here. I feel like this was an attempted murder, and we found a law that covers it. If she's found not guilty, what happens next? Then she'd be freed. I don't think she's held on any other charges. She would go free. She'd probably go back to the jail where they process her out. It can take a couple hours to do that, but she'd basically get everything that she had with her when she was brought in, given back to her. Any possessions that she bought and paid for while she's in jail, I think those go with her when she leaves. I think that's the case. But if she's found not guilty, she cannot be tried again. That would be against the Constitution. It would be improper to face the same prosecution on the same trial for the same charge twice once you've been found guilty. Double jeopardy. Not feeling murder. I think she shot him in anger to make him leave her alone. Not sure she intended to kill him. I know, but a reasonable person a reasonable person has to know that the action she took, which is shooting, could bring about his death. And I think most reasonable people could conclude that. We're seeing some motion in the courtroom. Did you get in trouble for the event escapade? Probably a write-up in jail. I don't know. There's probably not a checkbox on the form. It's like, oh, let's see what happened here. Where's got pregnant in jail? No, that's not there. It's not there, but I'm sure she got in trouble. What was the final deliberation time? 1 hour, 40 minutes. 1 hour and 40 minutes is what I got. 10 minutes to call 911 is not a good fact. It's not, but they had a reason or an excuse, I guess you could say, that he had in fact taken her phone, and until she found him, which she didn't find initially, she didn't have a phone to call 911. She doesn't have a landline. So until she found him, she couldn't call 911. Oh. Plus they had lunch. Oh my goodness. The jury had lunch and deliberated and came back with an hour and 40 minutes. Plus they had questions in there. The only trouble she got was pregnant. Can you explain the last photo thing? Donna, what we got is that the prosecutor in his closing used pictures that were not in evidence from the outside of the house, and also said something to the effect of there's no evidence that he ever stuck his arm in the window or anything like that. And he let the ball drop. There is a picture from inside the house showing cardboarded up windows next to the door. So all those pictures came in, the ones that were not in evidence, plus the one that was in evidence. And the defense, as a remedy to the prosecutor's mistake, which was nearly called a fundamental error, which is definitely mistrial material, the defense got to get the final word for a minute, got to talk and explain about that window and how that actually supports their story of having the broken window and the reaching in. Hey, bud, how are you doing? Kiki got a squirrel and is breaking its bones by chewing it? Yeah. Yeah, Kiki likes to chew squirrels. There you go. My cat caught another squirrel. We feed it. I mean, it's the cycle of life, I guess. The circle of life. I have some problems with this defendant. I think intentionally getting pregnant in jail, is her showing no regard for the child. And, the child needs his mom, and they're not going to, that's not going to be like, oh, sure, we'll just wheel the crib into your cell. It'll be good. You need diapers? It's not going to happen. You're putting a child in a situation that's not in his best interest. And then also during this trial, her young son was called to the stand to testify, which is also quite traumatic. Here we go.
Jury is telling us they have a verdict. I'm going to bring them in. Before we publish, before we publish, listen, the lawyers did a good job. I know there's family members on both sides. We will all keep our calm and composure. I'm not going to say it again. Anyone who disrupts these court proceedings will be immediately removed, number one. Number two, the jury did their job. They will not be felt one way or the other.
Don't feel the jury.
Influenced by anyone's reaction. Okay, let's bring him in.
All right,
All right, as the jurors come in here.
All right, all jurors are accounted for. We can be seated. Mr. Bowie, you're a foreperson. Yeah. Yes. Bowie, you have a verdict. Yes. So I'm going to review it just to make sure everything's been checked off appropriately.
I want to see the judge's face as she views
After, if it's all in order, the clerk will ask you each one if this is your verdict, and then we'll take it from there, okay? All right, Ms. Link. The State of Florida versus Daisy Link, case number F2211523. Verdict, we the jury in Miami-Dade County, Florida, find the defendant, Daisy Link, as to count 1, second-degree murder, guilty of second-degree murder. If you find the defendant guilty of second-degree murder, you must answer each of the following questions. Number 1, did the defendant actually possess a firearm during the commission of the crime? Yes. Number 2, did the defendant discharge a firearm during the commission of the crime? Yes. 3, did the defendant discharge a firearm causing death during the commission of the crime? Yes. So say we all, the 16th day of October 2025, signed by the foreperson. All right, Marilise, we're going to poll the jury.
The jury, if you heard the judge read the verdict, as I call your name, if this is your verdict, please answer yes. If this is not your verdict, please answer no. Keenan Bowen?
Yes.
Ramona Espinosa? Jacqueline Smith?
Yes.
Tiara Campo?
Yes.
Esther Montoro?
Yes.
Lawrence Vega?
Yes.
Judge, the jury succeeded.
Okay. I just have one more thing I have to read to you all. Let me just pull it up real quick. It's one paragraph long. Ladies and gentlemen of the jury, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. And with that, I thank you again. Please go outside with Umberto. I have a certificate of appreciation for you. I'll shake your hand. We'll give you back your electronic devices.
So before you do that, can we come sidebar? I apologize.
Sure.
What? Before you let the jury go, can we come sidebar? I apologize. That's the state who says this. Oh my goodness. This is a mess. This is a mess. Daisy didn't appear to show much surprise with that verdict.
Now we can all rise and you all can go outside with Umberto.
No, follow me.
One last time we get to see some shoes, maybe? Dockers. Ooh. Probably the best shoe show of
All right,
the
folks, we
entire
can go
trial.
off record for 2 minutes. I'll be right back.
That was a quick verdict. You saw Asics and Jordans? Good shoes. Ooh. Let's see what the judge is doing here. After 2 minutes. This trial was so big it couldn't be contained in one courtroom. That's how crazy it was. Sentencing today, probably a PSI first, I'm guessing. We're in Florida, right? With the judge tipping it for the defense, it was still guilty. Her testifying did her in, or her family's. Florida is automatic life. Is it automatic life without parole for second degree? No, it's for first. It would be. I'll come shake your hand. Interesting. She had no emotion.
We're back on record. Lawyers are present as well as Ms. Link. All right, Ms. Link, the jury's found you guilty. I will adjudicate you guilty. I'm inclined to defer sentencing for another day.
The defendant is not a convicted felon. She has several Pickles. She would otherwise be held as PSI. I don't know if the defense is waiving that or not, but I would, if we already have sentencing, other than the waiving of PSI, it would need to be regardless.
Do you want me to order a pre-sentence investigation?
Yes, please.
Okay. All right, so we'll order a pre-sentence investigation. They usually take about 8 weeks, so we'll just reset this for about 8 weeks' time. It's going to print tomorrow anyway, Mr. Tomas, because we're after a cutoff date for the clerk of court.
The clerk stops working.
8 weeks from now puts us roughly around Thanksgiving. So I'll just ask for the pre-sentence investigation to come back the Friday before Thanksgiving, the 21st. Is that all right?
That's fine. I can make myself available.
That's just for the return of the PSI. It's not for actual sentencing itself.
Now there's a motion.
Okay, so 21st is the next court date for the return of the pre-sentence investigation. If it's back then, we can pick a day for sentencing after we get the pre-sentence investigation. Is there anything that I need to address from the parties before we adjourn for the day?
I don't believe so.
All right. All right. Thank you all. We're adjourned. I can sign it tomorrow. Umberto.
So it's going to be appeal is the next logistical step they take. I don't think Daisy can fault her lawyer at all. I think he did a phenomenal job. She's getting fingerprinted right now. On the other hand, wipe off the ink. And she's now entered in the system, or will be entered in the system in the next day or so. Very tough in Florida to get a verdict overturned. I don't know of any trial that might go to an appeal. This one sure had some moments in it. All right. All righty. Wow. Color me surprised a little bit. That quick verdict normally doesn't happen like that, but let's see. Let's see if we can go back to our other surprise positive or surprise negative. I think, like I told you, I think she tried to commit murder and then found that it might have been legal. That's what I... Now for a less chaotic trial, let's go with the pro se soft sit. Wow. Not really armed and running away. Well, yeah, the jury found it was not legal, but they found a law that could have sheltered her actions. Had the evidence been a tiny bit different, it would have covered it. Didn't work. The jury did not buy it, even for a second. But let's see. All right, let's jump back to trial where we are watching this juicy one that Josh brought us. So let's do that.
Request for me to recuse myself is denied. I do not believe I have a conflict in this case, nor a reason to recuse myself. If the sole reason to recuse myself was because I have a defendant in front of me in which I was the prosecutor prior, I will say, other than maybe one judge, there's not a judge in this 2-county area that would be able to hear the case. Additionally, I don't believe just because I was a prosecutor, both elected and a chief assistant, doesn't rise to the level of being recused. I will state before that I was a public defender. I will also state that while I am familiar with Mr. Du Bois' name, I can honestly say I do not remember one case that I prosecuted him on. So I don't believe we've risen to the level of a need to recuse myself.
Yes, Your Honor. Thank you.
Mr. Niegos, are you requesting to move forward then today with the preliminary examination?
Yes, Your Honor, please.
Any additional matters before we start?
Apparently, defendant.
I would just ask that the witnesses be sequestered.
Ms. Carey, do you have any witnesses? All right.
I don't.
I will order that any witnesses be sequestered. I will also state for the record, because we didn't do this before, Mr. Niegos appears by Zoom and Mr. Du Bois appears by Zoom from he appears by the Wexford County Jail. Due to some threats that were made last week, the court felt it best for court security purposes to conduct this hearing by Zoom. Ms. Carey, your first witness.
Thank you. The people called Deputy Shane Rojas.
Your Honor, can me and my attorney have a moment in the breakout room, please?
Mr. Niegos, you want a moment?
Yes, sir.
He says no in his head, rolls his eyes and says yes. Okay, so now the bailiff has to leave. This is a private meeting with his attorney. If you could figure out how to do the breakout room, Judge, that would make it a little easier. Tech is hard. Zoom is hard. This attorney. Hey, that's a nice watch. What's that attorney wearing? Okay, Mr. Niegos. Out he goes. We're going to zip, zoom ahead because we can. What are they doing in court right now?
Signed, but we also have a bond violation that we need to deal with.
That's a different thing. That's a different hearing. Okay, he's coming back. So we'll finish up with the guy that's in orange here. They just used that to fill the space while the meeting went on. Attorney's coming back.
Are you asking her to confirm that, or me?
Well, that's what the court has. So looks like
there were two allegations.
There were two allegations.
My apologies.
Well, I think we were originally here. I think we were originally here on the failed to test, and then we tested positive while we were here for the failed to test.
I think that sounds right now that you mentioned it, Your Honor. We can proceed.
To both allegations?
Sure.
All right. Mr. O'Neill, is that how you still wish to proceed?
The misdemeanor fail, I went to Traverse City unit to test that day.
Okay, well, before we get to that point, do you wish to proceed as your attorney had said that you'll be guilty to the mistest and the positive test?
Well, guilty to the positive, yes.
But not guilty to the mistest?
No, I'd had the receipt and everything for the one in Traverse City.
Okay.
We have it?
It was emailed to us, but I don't.
That was my confusion. I thought that had been dismissed.
I got it.
What's the date on
It's 12 hours late.
12 hours late?
12 hours late.
12 hours
Let's
late.
carry, I'll leave that up to you.
Mistaste.
How do you, was when?
October 4th at 8:08 p.m.
Then it's supposed to by 8 a.m.
All right, so you want to move forward on the violation, on that count?
I like the unbuttoned top button look with the
My
tie.
apologies, Your Honor, that had slipped my mind.
All right, so then, Mr. O'Neill, it will just be a guilty plea then to the positive test.
Yes, Your
All
Honor.
right, so did you test then?
I'm going to fast forward because we don't need this one. We need this guy. There we go.
Cocaine?
Yes, Your Honor.
And did you use cocaine after the court placed you on bond on September 29th?
Yes, Your Honor, I did.
All right. Do you counsel believe the defendants provided a factual basis?
I do.
I do too.
As does the court. Sir, I find you in violation of your bond conditions.
The defendant says
and
I
that
did
brings
too.
us to what we do from here on out. So, Mr. Harrison, any comment regarding bond?
Well, Your Honor, obviously, this is a situation where Mr. O'Neill clearly has a problem. He's acknowledged that. I spoke to his wife earlier today. She's discussed that they have, this is something that they have anticipated, unfortunately, was going to be an issue into the future, and we're going to get him some help. And they're still willing to do that. He's still a relatively young man. He was spending untold amounts of money just to fuel his habit prior to this situation, and unfortunately was unable to not give in to that temptation. I would encourage the court to reinstate some kind of bond here, although I understand the court's reluctance, apparent reluctance to do so. And I don't say that lightly in terms of trying to be facetious about it at all. I do see the dilemma that he poses to the court, but I can tell you, based on conversations that I've had with him and his wife, that he is serious about recovery, and she is serious about supporting his recovery. I would like to see him out on bond so we could perhaps explore options that he may have in terms of treatment and other resources that he can pursue immediately on his own accord prior to there being any quote unquote requirement to do so. I think he's a good candidate for bond. I think with a increased testing regimen, he knows if he didn't before, I think he did know before, but this would certainly be the situation in which he would not have any room to say, I didn't realize that I was staking my liberty on my sobriety, but that's what he's doing.
This guy talks forever.
Thank you.
Mr. Harrison, has there been any contact with Nimri while he's been in the jail to see if he can get into
We
it?
really haven't had a chance to get him one.
As a March 2024 conviction for use of cocaine, and then from what I've heard today.
Yeah, the bond will be forfeited as well. Okay.
Sorry.
Thank
we
you.
came for
Thank
this
you.
one.
All right, court recalls the case of the people of the state of Michigan versus Bobby Lee DuBois, case number 253691FY. Mr. Gallegos, have you had the opportunity to discuss matters with your client?
I have, Your Honor. I didn't get a full and complete opportunity to explain to my client what I'm about to say on the record because I didn't get a chance to speak. But essentially, my client's request is as follows. He wishes me to ask for an adjournment of this matter because he has initiated as he calls, an investigation into the actions of the primary troopers who investigated him in this event. He believes that the results of that investigation are paramount to his ability to present a defense in this case. He's also instructed me to subpoena some guards from the local Wexford County Jail for, at this point in time, I'm not sure what reason that would be towards a preliminary examination, but that's nonetheless his request. And the thing I didn't get a chance to tell him is to remind him that as this entire proceeding is now pending, he has no bond. He will have no bond. He's sitting on dead time. There's a parole hold on him. And whatever this MSP investigation that is or is not happening, he believes that it is. I have no information or knowledge of, nor do I believe it's paramount to my ability to effectively represent him in this case. That being said, my understanding is he wishes me that I ask for this adjournment, which I'm doing at his request against my advice. And I would ask that the court ask him directly if that is in fact the case, if he does in fact that this examination be adjourned once more, even though I'm here prepared to go forward today, despite his earlier complaints about how long it's taken to get all of us here. Thank you, Judge.
Mr. Du Bois, your attorney has placed on the record your request. Is that your request?
It's almost completely accurate. The part about an open investigation against Deputy Roloff and Deputy King for the initial stop is actually underway. I've dealt with state troopers in regarding to this matter, and I think that moving forward, I don't see how it could be anything that Deputy Roloff or Deputy King says until the end of that investigation. I don't think how it could be pertinent to what we have going on. And I would be more than willing to sit this dead time and deal with all the time that may occur up until now, until the resolution of that investigation is done, because there's going to be wrongdoing found, I believe.
So, Mr.
In regards to this,
what is the nature? And I don't want you to get into the facts of it, but what is the nature of your complaint to Michigan State Police?
It's not the Michigan State Police. It's Deputy Roloff and Deputy King of the Grand Traverse County.
But you said that the state police were investigating it. So what was the nature of the complaint?
There was wrongdoing by Deputy Roloff and Deputy King.
Are you alleging
in regards to the drug, in regards to the possession? I'll say that.
Are you alleging that they're untruthful in some way?
Absolutely.
Mr. Niegos, do you want to follow up or supplement anything?
He's like, no.
Absolutely not.
Absolutely.
Ms. Carey, any arguments?
Oh, man.
Can we have Ms. Chandler subpoena to court, please?
I'm a little bit perplexed. We've been here 4 times, and I know some of that has been on our part. I have the Grand Traverse County deputies here and ready. It is now almost 5 to 5 or 10 to 5. If the defendant wants to prolong this pending an investigation by the state police, that's up to him, I guess, and to the court. But just so he knows, it could be more than a week, and I don't want to have them come back for the 5th time next week. So if we're going to have it investigated, and not schedule it until we're certain that investigation is over, then that's fine. Otherwise, we're prepared to move forward.
Well, it sounds like what Mr. Du Bois is asserting is some sort of Brady violation, and I will admit it's been a while since I looked into Brady, but as I recall, during other Brady issues I had, it's not necessarily appropriate to raise a Brady issue at the preliminary examination. It would be more appropriate for a trial, and that issue would be raised by trial. Presumably, if we were to move forward for preliminary examination, any investigation by MSP would be done by then. But even if there is some sort of investigation, that doesn't necessarily rise to the level that there be some sort of violation of either Brady or Giglio. So the court is prepared to deny that request today. But as Ms. Carey indicated, we are already at 5 minutes to 5, and I don't see how we can do a prelim today. But are you guys able?
I mean, I am.
The court and staff are willing to, if the party, Mr. Du Bois, it's my turn now.
Yes, sir.
If the parties are willing to hang over, we can we can at least get started on this and see where we wind up.
Your Honor, may I speak?
Mr. Du Bois, you have done more talking than any other defendant I have let talk in the last 3 months. Every time we come in, you complain that it wasn't moving fast enough, and now today has been nothing but stall tactics in order to get it stopped. You've had 3 months to file a complaint with Michigan State Police. They've had 3 months to investigate it. We're here for a preliminary examination today. I have to get this case moving. You can shake your head all you want. You can shake it all you want. But, you didn't have a prelim last week because of your own actions, and now you're asking for another an adjournment today.
That I did. That it was my fault. My child rights are being violated, and you're just letting it happen. That's why Ransom was going to throw it out the first time. What do you, I'm not being heard. You are, that's why I'm saying you're biased. You have tried me before in 23, 22. You come from the prosecutor's office. You and Joanna Carey are openly friends. How am I getting an unbiased fair chance here? Furthermore, I tried to fire this attorney already. I want to represent myself. Who knows my case better than I? Me. At this point, I would like to dismiss Mr. Niegos under the, I would like witnesses called at a prelim hearing. I believe I'm entitled to those, Your Honor. I believe I'm entitled to call my own witnesses. I believe I'm entitled to ask questions against, for the officers. None of this stuff. I feel like I'm just being pushed through, and I've been through this enough, Your Honor, that I know I got all the paperwork here that says what I'm entitled to. And yeah, I do talk a lot. You know why? Because I know what my rights are. And every time I don't, I get pushed through this system and I get screwed around. I do. And the investigation has started since day one. Since I come into this jail, I asked to speak with a state trooper. You can call them, get in touch with them. I encourage it because there's wrongdoing here.
Mr. Niegos,
I'm sorry, it's frustrating you. Imagine how I feel.
You're not frustrating me, Mr. I'm here all day, Mr. Niegos.
Here all day.
Your Honor, I obviously, I'm yammering and stammering. I'm not entirely sure what to say. He's representing. He knows his rights. He's representing. He tried to fire us before. I did have an opportunity to speak with him. I probably should have put this on the record as to the whole MFR thing in the note from last week. He indicated he was not referring to me or my firm.
There was an MFR thing?
I was going to continue with him. Based on his representations here today, I am absolutely more than fine to step aside. And since he indicates again that he knows his rights and etc., then if the court's inclined to discharge me, take zero offense or issue with that.
Has the attorney-client relationship broken down, do you believe?
Yes.
I know that there's been a previous significant issue between he and a colleague of mine in my firm. The relationship between Mr. Du Bois and myself has not been a upward linear one, so to speak. And based on his representations here today, indicating that he's repeatedly, in his words, tried to fire me, as if indicating somehow I've insisted or I have some sort of vested interest to remain on this case as his counsel. I believe so, Judge.
Because I do not.
What about the interview between us that was scheduled yesterday? You've missed two.
Okay, Mr. Du Bois, Mr. Du Bois, this is the perfect example. He's saying that the communication process is broken down. He wants out, and yet you want to argue with him. Why, I don't know, but you want to argue with him about that.
Because I want it on record why. I'm not just being disruptive. I'm stating what's going on. I should have an attorney that can come in here and sit down with me and go through my case, not 10 minutes before we come before you. This is the problem here. This is how it goes for every inmate that comes in here. If they're not paying for an attorney, they come in here, the lawyer sees them for 5 minutes, they don't go. How much time have you spent on my case? Tell me some specifics in it, Your Honor. Nobody can. That's why I'm raising such a fit about this. It's unconstitutional. You tell me that I'm getting a good defense by one of these lawyers that spend no time. He's on Polycam. We have not sat down one time and went over any part of my case. Not one. You tell me how that's constitutionally right and fair to my fair and speedy trial. Am I right to be represented by a decent attorney? I don't understand why you guys can't see what I see and what other people see. I don't get it. I'm not trying to waste time. I'm not trying to be disruptive. And you know what? I take full accountability for my actions, why I'm in these chains, and
no,
why
I wouldn't say that.
I
wouldn't be saying anything about accountability or why you're in those chains before you fire me formally. Don't say that.
That's my parting advice. Don't plead guilty in front of the prosecutor.
I want an attorney that will come here, sit down
All
with
right,
me and
Mr.
go
Du Bois,
over my case.
let me ask you a question. Mr. Du Bois, let me ask you a question.
Yes, sir.
Do you want an attorney or do you want to represent yourself? Because you've said two different things now.
I want an attorney that will come here and that will go over my case and give me the time and respect that I get.
I have no control, Mr. Du Bois. I have no control over who the public defenders appoint. I have no control over how they conduct their interviews. I have no control over that. All that has been removed from the court back during the reforms that started the Indigent Defense Commission. I have no control over that. All I can do is, it sounds like, based on what Mr. Niegos has told me and what you've told me, all I can do is order that Mr. Niegos is removed from the case because there's been a breakdown of the attorney-client privilege. You might get Perry Mason next time, or you might get Barney Fife. I can't say who you're going to get next time. But I do not have an endless supply of attorneys. Do you understand that?
I do understand that. And I don't, am I not entitled to a good defense? Am I not? 5 minutes before we come before you, Mr. Wiggins. Go ahead, sir. I don't want to interrupt.
Thank you. You're doing a very interesting job of not showing that. As I said, I have no control over who is going to be appointed to you. And yes, you do have the right to counsel, but you also have the right to hire your own counsel if you are not happy with the counsel you're receiving. And where you're indigent, which is what you are, I can't just go start knocking on doors and saying, please represent this person. There are attorneys that are under contract and under hire with the Wexford Missaukee Public Defender's Office. I have no control over that. So I'm willing to release Mr. Niegos. It sounds like he's in favor of that. It sounds like you're in favor of that. But I have no control over who you're going to get next.
But
I want to make sure you're clear.
Have control over how they conduct what, 5 minutes to go over. We haven't went over anything in my case. Nothing. Don't you have? Can you point me in the direction of who to complain to? It's not my fault. I'm indigent.
I completely agree.
Who can I complain to so I can get proper and adequate representation?
Mr. Du Bois, if you would give me 5 seconds, can you do that for me?
Absolutely.
You can contact the public defender's office here. They can direct you in a way to make a complaint. As I said, this is not the old days where the court had control over the public defenders. I don't do that. I have no control over who gets appointed, the directions they take a case. That has been entirely removed from the court. That's between you, the state of Michigan, and the Public Defender Indigent Defense Commission. But based on what I'm hearing today, I will remove Mr. Niegos from this case. We will make another referral to the Public Defender's Office for the appointment of an attorney. We'll get everybody back here, but I'm not going to set it for next week. I'm going to put this off until it's going to be, and I'm not going to reset it for a probable cause conference. This case has gone on long enough. It's going to go right back to the preliminary examination. So because of that, I'm going to set it out a little bit longer. We'll go out at least 2 weeks. In the what?
28th of October.
The 28th of October. If the parties can agree and the court finds there's reasonable grounds to put this back on for preliminary or a probable cause conference, I'll consider it. But it's going to go on the docket as a preliminary examination. Nor can I even guarantee that by the 28th you'll have an attorney. I had another case today that's been almost 2 weeks, if I recall correctly, that they're still waiting for an attorney to take the case. So just so you're aware of all that.
Can I represent myself until then?
I have to be convinced. Hold on, before we go any further.
Hold, please.
Everybody in the audience, I'm sorry. We're now over our time. We're going to have to adjourn the prelims for this afternoon, and we'll get them rescheduled for another date. They're going to be rescheduled for 2 o'clock on Monday,
The 20th.
the 20th.
It's on the front end.
You can go out to the front windows where you checked in and get your next court dates. Again, I apologize, everybody. It just ran longer today than what we'd anticipated. So, Mr. Du Bois, back to you. I need to be convinced that you are able to represent yourself. Yes, you have a constitutional right to represent yourself, but that's not an all-encompassing right. The court has to be, and you can let the jail go as well. The court has to be convinced that that is a knowing and voluntary waiver of your right to an attorney, and that you have the wherewithal to represent yourself. So before I go ahead and do that, we have a process we're going to have to go through, but I want to be very clear. Are you asking to represent yourself, or are you asking to have court counsel appointed or indigent defense counsel appointed?
I'm asking to be able to have the resources to represent myself and look into my case law, and reference those things until an attorney is appointed so I can better represent myself.
Well, but see, therein lies the problem, because you can't represent yourself in between time of an attorney being appointed. If you've requested the appointment of an attorney, the attorneys can't talk to you, and I can't talk to you in very limited circumstances until you have an attorney appointed. So that's why this question is very clear. Are you requesting the appointment of an attorney, or are you wanting to represent yourself? You can't have it both ways, just so you're clear on that.
So I can't be granted access to a good legal law library so I can actively participate in my case until I have.
You can do your own. You can have access to the law materials, but because you've requested a court-appointed attorney, you can't make any filings with the court, and you can't have any communication with the court or the prosecutor's office, except in very limited circumstances.
Okay. Yeah.
Does that make
I would
sense?
like to try to get an attorney, a public defender that I can work with and that will come here, and to save time for you in the court, all I'm asking for is an attorney to come in, review my case with me, take an interest in my case, so I feel like I'm adequately represented, because at this point, I don't feel like I have been. You can't adequately represent somebody 5 minutes before they go into court, Mr. Wiggins. That's been my whole thing. That's been my whole case. That's why I'm frustrated. That's why I'm an animated person by nature. Anybody will tell you that. The people at the jail, anybody that knows me, I'm animated by nature. I don't mean disrespect by it. And yes, I do get on a rant sometimes, and I am long-witted, but that's because I suffer from disabilities. That's just what it is. And I'm sorry that you feel like I've wasted your time, but this is important. This is my life.
You're not wasting my time. As I said, I'm here all day, 5 days a week. But now Mr. Niegos, I've released you, so if you want to go, you're more than welcome to do that.
Normally, Judge, and I do apologize to your staff, normally, especially since the time. Normally, I don't respond to these kind of comments because he's not the first nor the last that says these things. But in this case, given the documentation we have in our file and the comments he made, I just would like to put on the record that we've attempted multiple, albeit remote, jail visits. The first one was conducted with my legal and with my research and writing specialist, who does all of our
when they didn't show up. When they didn't show up, it's documented.
Mr. Boyce, Mr. Du
Yes,
Bois,
sir.
you had your time. Now it's Mr. Niego's time. You made all kinds of accusations against him. Now it's his turn to defend himself.
Yes, sir.
So the first attempt for a virtual visit, which is always the initial visit that we handle to go over the police reports and the initial things, happened on October 13. The notes in the file. This was also a case that I accepted on short notice. It actually occurred on October 2nd. I apologize. And the notes in the file indicate that essentially the visit was conducted and was terminated due to Mr. Du Bois essentially not liking what he heard in terms of what potential defenses and such he may have had. Another visit was then scheduled for yesterday that Mr. Du Bois is referencing. He and I spoke on the phone last week. The sole purpose of that visit was to discuss the note from last week and whether or not I would stay on as counsel for him. And during our phone call last week, he and I agreed, or I agreed at his request, to stay on. And finally, the last point, Judge, in terms of what we did or didn't do, as he can at least attest to this, he's got copies of his police reports. This is a preliminary examination. I spoke with him. The anticipated outcome of the preliminary examination and the anticipated motions we'd be seeking to file in court. The bottom line is this, Judge. This is an individual who knows the laws and knows his rights after he allegedly committed crimes. And at this point in time, it's, of course, his defense attorney's fault for him not adequately being represented. I was ready to conduct this preliminary examination. I've explained to him the motions that I anticipated filing based on my assessment of the case that would have led to a bind over, given the evidence in this case. He doesn't like what I had to say. I respect his wishes. I wish him nothing but the best. But in terms of the representation, and it's not just me. I have people that are very helpful, that work very hard in our firm, who try to do the things that we do. And a lot of what we do is service communities like Wexford, communities like Misaki, communities like Sheboygan, places in northern Michigan as well as southern Michigan, where frankly there are not many standard 7 qualified attorneys to handle capital life felonies. My firm does an abundant amount of appointed cases by choice, not by need. And I wish Mr. Du Bois all the best with whoever other public defender or conflict attorney on the roster accepts his case. Thank you for allowing me to put that on the record.
Thank you. Now,
Bye,
Mr.
Mr.
Bois,
Diegos.
you raised
We miss
another
you
issue,
already.
and that is a friendship between Ms. Carey and myself. And yes, well, Ms. Carey and I had worked together for a number of years. She was also my chief assistant prosecutor while I was the prosecutor. And yes, we did have a friendly relationship. But I will state, since becoming judge, I don't want to say that friendship has ended, but as far as Ms. Carey and I doing anything together, that has not happened at all since I was judge. The most time we spent together was a couple of weeks ago at a conference with 4 other persons, including Mr. Champion, the chief public defender, and the community corrections director. So as far as your allegations that I can't be impartial because of a friendship that I have with the prosecutor, I don't find that persuasive. I've ruled against Ms. Carey in a number of cases as the judge, and I've ruled in favor as the judge. I've also ruled in favor against all the other prosecutors. We're in a small community, and unfortunately that's how small communities work. But I have the ability to separate myself from any friendship that I have with somebody to make sure that justice is carried out. And if you aren't feeling that that's being done, I apologize for that. But that's simply how it is. But you can certainly raise these issues with your next attorney once they get appointed. And if you feel and that attorney feels there's need to go ahead and file a motion to recuse myself, I'll certainly hear that motion again.
I have one now. I've written it myself. I tried to follow
But Mr. Bois, you requested the appointment of an attorney, so the court can't hear that motion.
Well, but I asked him to do that before this, and do you see the problem that we keep running into?
But again, that's water under the bridge. I'm just telling you, moving forward, you can discuss that issue with your next appointed attorney. All right?
Okay. Yes, sir.
Okay, we are adjourned.
All right, brother.
So we're going to have to add this to our watch list for sure. Welcome to Bakers, and I think we got some folks from Trial TV Live here as well. Broken Bakers, thanks for coming in and raiding us here. As we are wrapping up the day, we got a verdict in the Daisy Link trial. We're going to listen to the song one more time because we can, but we do have a song for you to listen to. that was inspired by the Daisy Link trial, just to wrap things up and get us ready for Thursday evening. Podcast Thursday, might add. Podcast tonight on this channel, 8 p.m. Looking for where I've got the song. It's over here. I think it's right there. There we go. All right. We have to go there. Where's my library? One more short case to end the day. One more. Oh, let me look. What do we have, Josh? Oh, Judge Dad? Let's do a quick check. Judge Michael K. McNally. George Michael? No, you didn't hear me right. Judge McNally. Yeah, there's so many channels with his stuff, but I need his channel. There he is. All right, this one was today, right? 5 hours ago. And we're looking for timestamp 36 minutes and 36 minute mark. Josh, I'm looking at the 36 minute mark and I don't have anything from that. Oh, it's before this. 33.
Charges under township. It looks like what they did is,
hold on,
they cited under local ordinance. Charge C is a state civil infraction. So you're moving to dismiss all of these cases and they're going to reach charge under state law on all of them.
That is correct.
Okay. I'll go ahead and dismiss this. File A, B, and C without prejudice. Okay? Thank you very much.
Okay, I'm looking for the right clip. Hang on one second. 36 minutes. There she is. I think. 34. 35. 36. It's not at the 36 minute mark, Josh. Billy Wells case. The screenshot you sent me just doesn't match. He had 2 videos today. Is it this guy?
Thank you. Evan Maurice Miller, 25T645605.
This is 36 minutes on the video he sent me, Josh.
Are you in here on something?
He had 2 videos today.
Okay, wait, let me just take this one. Your name?
Okay, hold on. We've got the wrong video. So the one from 5 hours ago is not the
Have
one.
a trial. Do you understand that?
We need to go right here. Okay, I hear you, Josh. 36.
Community service, will you please?
Yes.
Did you do your court work?
Yes.
Okay.
Just
well,
wrapping
then
up
let's
this one.
just
It's the
do
next
this.
trial. We're watching
Oh,
Billy
wait, I
Wells.
almost have to extend, don't I?
Looks like he's a truck driver, or he's an RV.
No, she's that's right. That's right. Listen, I'm going to dismiss the show cause. I want that community service done.
Okay, Billy, where you at? There we go.
Here today.
Billy Wells here. Doesn't have a video now.
Billy Wells, what's going on, Mr. Wells? People in Billy Wells. 258-244-915 A and B. Your name?
I forgot I was in the middle.
My name is Billy Wells.
Mr. Wells, how are you?
I'm fine, sir. Just having problem with these old phones. You know, my kid's not around.
I get it. You're at my age. I get it. I
Yeah,
get
that's
it.
it. That's it.
I get it completely. Listen, it's kind of getting late in the morning. You live in Arizona?
Arkansas, AR.
Oh, Arkansas. I'm sorry.
Arizona is AZ.
Thank you for enlightening me. I needed that. Stop smoking, will you?
I know it. I know it. That's my only habit, though.
No. I mean, you're still in court here. I can't have you smoking in court. All right. I mean,
Oh, well, you know what? I didn't think about that. I'm sorry.
okay. Look, I got a reasonable guy here. I'll do one of two things. I can give you a lawyer, or I can arraign you and let you speak to the Flat Rock prosecutor.
Okay.
Do you want a lawyer, or do you want me to arraign you and let you talk to him, and then if you don't like what he offers?
Here's what happened.
No.
Go ahead.
I just need to know if you want a lawyer or if you want me to arraign you, explain the charges and the penalties, and then you speak to the prosecutor yourself. What do you want to do?
I can speak to the prosecutor myself.
All right, I'm going to go ahead and arraign you. You're charged with operating a commercial motor vehicle while your ability to do so was licensed, suspended, or revoked. That is a misdemeanor punishable by up to 500 fines, 93 days jail, costs are all those 2 points, at least 2 points. And you have a second charge here of impeding traffic. Do you understand that?
Yes, I do.
You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial, right to bring in your own witnesses at a trial, right to cross-examine theirs. If you plead guilty, you'll be giving up all those rights. You'll be waiving the presumption of innocence and the requirement that they prove you guilty beyond a reasonable doubt. Do you understand that?
Yes, I do.
All right. You still wish to waive your right to a lawyer?
Well, can I explain it to you, though, sir?
No. You either got to tell me, Judge, I want a lawyer, or I don't want a lawyer.
I want a lawyer. Can I
All
get
right.
it today?
I'm entering a not-guilty plea, $500 personal bond. You can leave the state. You can leave the state since you live in Arizona without consent. You cannot violate a law. You must appear in court as directed. Arkansas, rather. He'll take the file to the attorney who will represent you. The lawyer will get on and speak with you, and he'll speak to the prosecutor. Then you're going to come back in front of me, okay?
We're going to do it on Zoom again?
Yep, we're going to do it right now.
Okay.
Unless I can put this off for another couple of weeks if you want. It's up to you. I can do it today, or we can put it off.
We can do it today if we.
Okay, good enough. We'll give you that lawyer, and he'll be right with you, or she.
Okay.
I'm gonna get the Shemke because the ball was up. The gentleman in the courtroom, Mr. Farrell, it's 11:30 with Durwood.
How far ahead do we have to skip for the next appearance?
Durwood.
Okay. He wants to speak to a lawyer. So we're going to give him a lawyer. We'll give it to Mr. Carmen, let him speak with the guy, Mr. Wells, and then we should get out of here, okay?
I'm okay if you just want to judgment.
Well, I offered that. He wants to get it over with today.
Okay. Carmen's still around, Michael?
They said he was.
I think we give it to Shemke. Somebody who's around.
Okay, cool. All right.
Thanks. Thanks.
Okay, let's see where we have to see when they come back in. That's not him.
What do you want to do?
Is
she gonna...
Okay, he comes back in right here.
So this would be a first violation.
Looks like he stopped at the truck stop.
All right. I'll take that as a given because I didn't see him. I'm sorry.
Yeah, they weren't right.
All right. So let's go through this. What do you want to do? Is she going to plead or does she want a hearing?
Guilty with an explanation.
Young lady, if you plead guilty, you could get 5 days on each of these cases. I could revoke your HIDA status. You'd be subject to a 90-day jail term. I have to tell you that. I wouldn't be all nervous about it. You understand that? Did you sign an advice of rights form here today? Did you read it and understand it? If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing of any kind. You understand that? Okay. To the charge that you failed to provide proof of completing your community service 16 hours by September 15th, how do you plead? Why did you fail to do that?
I was ordered 8 hours, yes.
Ordered 8?
Yeah.
Well, what happened? Why are we charging 16?
I'm not
So
sure.
Judge, she did the hours, but she didn't do it at a non-profit. She just was under the understanding as long as she did free work somewhere.
Like voluntary work.
It would.
Like, where'd you do your voluntary work?
It was from a doctor, so I was unloading and bringing down boxes.
For who?
Well, his name is Josh Tucker. He works for Rug Doctor.
For what doctor?
Rug Doctor, like the carpet cleaner.
Oh,
Rug
rug
doctor. So I worked for my boyfriend for free.
Your Honor.
I get
do
it.
see this must have been a Miss Wiles' mistake. I do see that she was only ordered 8 hours.
What in the world's going on in this case? Why haven't you done this yet?
So she did, she just did it at.
I know,
like,
I get it, but
For profit agency. This has to be a non-profit.
I get it. All right,
I get it.
I'll accept. Tell you what. When's your probation on?
January 14th of 2026, Your Honor.
Look, I'm just gonna do this. I'm gonna dismiss the show calls. Do your community service, will you please?
Yes.
Did you do your court work?
Yes.
Okay, well then let's just do this. Oh wait, I almost have to extend, don't I? No, she's that's right. That's right. Listen, I'm gonna dismiss the show cause. I want that community service done. Young lady, I want that community service done by November 7th. Okay, let's not make a big deal about this. I can't believe that guy, what did he do? Send a letter saying she helped me out and let her go and I made money off of her? Or did he pay you too? What a great country. So he got community service in his favor, right? All right, go ahead, go take care of your community service. Show cause dismissed. Good luck to you. I sincerely wish you well.
Thank you, Judge.
Thank you, Judge.
Okay, Billy.
Are we
you up?
done yet, or what's going on here
You
today?
got Billy.
Billy Wells here. Does have a video now.
Billy Wells, what's going on, Mr. Wells? People in Billy Wells.
This is one we watched before, right?
4915 A and B. Your name?
My name is Billy Wells.
Okay, we watched
Mr.
this one.
Wells, how are
We're supposed to go forward and see when he comes back. And I said I went back and watched what came right before him. Let's see. Mr. Wells comes back. Anywhere?
Fine, I'll accept both, please. Dismiss the
Oh, he's driving.
CDL charge. The operating a CDL while unlicensed or suspended. I'm going to charge you $250 on file A and $295 on file B.
He's actually driving right there. Hang on.
Mr. Carmen, there you go. Your name.
Billy Wells.
So, Mr. Carmen, he's going to plead to impeding 2 counts. They're going to he has a valid CDL
Shifting
now, and they're going to
gears.
dismiss that. True?
Correct, Your Honor.
The charge impeding traffic on file A, responsible or not responsible, Mr. Wells?
Responsible.
On file B, responsible or not responsible?
Responsible.
Fine, I'll accept both, please. Dismiss the CDL charge. The operating a CDL while unlicensed or suspended. I'm going to charge you $250 on file A and $295 on file B.
Got that lighter
That's the
hanging
charge, customary charge for the CDL on file B. So I'm cutting you a break on the first one. So you owe $545. Can you pay that today?
No, sir.
How much you have today?
Uh,
John?
Yes, sir.
This has to go back and then verify.
Oh, no.
Jennifer.
How much do you have today,
get
sir?
home first.
Well, tell me when you can pay it, sir. Come on.
What if I just split it in 2 payments?
You're not driving now, are you? You look like
I am, sir. I got an ear headset on.
you can't drive while we're conducting court, for the God's sakes.
Yes, sir.
I'm going to give you until October 30 to pay on file A. That's $250. I'm going to give you until November 14th to pay on file B. That's $295. Good luck. If you need more time, you call the court, go on Zoom on or before either one of those dates. I'll give you an extension. Thank you.
Thank you, Your Honor.
You understand everything, Mr. Wells?
He's still driving.
Thank you.
He missed all that. He's just be hanging out in court for a while. Okay.
Wasn't sure if he was gonna catch.
Okay.
He was driving. I was like,
What?
wasn't sure if he was gonna catch that he was driving.
Oh, Mr. Wells driving?
Oh, yeah.
That's great.
Yes, sir.
Yes, sir. I can still hear you.
You're all set, Mr. Wells. Did you get your due dates that the judge said?
No, I
Did you
did
hear-
not. I didn't hear.
Your one for 250 is due October 30th, and your one for 295 is due November 14th.
Okay.
Okay?
Okay.
You're all set. You can disconnect now.
Okay. Thank you.
You're welcome. Have a good day.
He just found a place to pull over. Now
Thank
he can
you.
light up
Bye-bye.
as well.
Bye.
All right, that was a fun little ending to court. The judge was so done. He's like, "Get me out of here. I'm done. I'm out of here." All right, now we get to play our song. We saw the verdict in the Daisy Link trial. It was a very quick verdict, hour and 40 minutes total, and then they had lunch in that time too. So for the last time, we're playing Daisy in the Walls, a song inspired by a story about a woman who gets pregnant in jail via the air vent with special deliveries. It's passed through the air vent. So let's go ahead and give that a listen one more time for old time's sake, and then we'll be wrapping up for tonight.
Through the cracks in the stone, I heard your voice, a whisper in the dark, no other choice. Metal bars can't cage the dreams we spin. The air vent carried you, and I let you in. The world won't understand this kind of fire in a concrete tube. We built our empire. Daisy in the walls, reaching through the night, planet in the shadows, growing toward the light. They'll call it madness, but it's just our way. Daisy in the walls, blooming every day. Your letters came in secret, folded tight, promises of freedom under the moonlight. A strange kind of love, but it felt so real. Through the vent, your touch was all I could feel. They say I'm a sinner, they say I'm a thief, but in this gray box, love's my only belief. A package of hope in a world so grim. Life from the void, I carry him. Daisy in the walls, reaching through the night, planet in the shadows, growing toward the light. They'll call it madness, but it's just our way. Daisy in the
go. With that, we can wrap up. Best use of icons. Bree, oh my goodness, Bree is the best at telling a full case story in emojis. It's worth watching. It's worth sitting through an entire trial just to see her summation of the trial using emojis. Thank you, Bree. Appreciate that. Think Daisy would like that one? Yeah. Well, I'll tell you what I'll do. I've posted it online. I think we've shared it. You can find all of them over on our Top Mark Media website. In addition to the song I wrote last night about the bad customer and the Facebook issue, that was crazy. You can find everything there. There's the link to Top Mark Media. Can you portal us to the podcast? I could if I had made it already, which I have not. I can't portal to the podcast, unfortunately. We're going to start. The podcast is at 8. It's 5. It's this many hours until we get the podcast. So 8 o'clock. Please join us for that. Brewers tonight. Fingers crossed. Come on, they've got to win. Got to win. Come back for the podcast. We'll have a lot of fun. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live. 8 o'clock tonight with the Not Relevant podcast. Join me for a little bit of fun. Thomas will be here. It's going to be a blast. Guys, we'll see you later tonight. Bye-bye.
Hush! Now I'm trying to have court. You don't raise your voice again.
I think I'm about to catch a whooping.
Thank you, sir. You're my new best friend.
What more do you need to see?
I got a stubby little pencil.
It's bigger than you. It's bigger than me. It's bigger than all of us.